May it please the court. Counsel. Members of the jury, good morning. Thank you so much for coming back. The evidence in this case has shown that on August 1st, 2014, this defendant was out partying. And for him, a good time included 14 beers, 1 to 2 shots of liquor, Xanax, cocaine, and marijuana. And after making the choice to consume each and every one of those substances, he then made a choice to get behind the wheel of a car and drive. And by doing so, he chose to gamble with his own life, with the life of Jordan Nedeau, and with the lives of anyone out on the roadway that day. And it was this defendant that made that choice, this defendant that took that risk and that gamble. But it was Jordan and her family that lost everything that day. I have to prove to you DUI manslaughter. And to prove that, I have to prove that this defendant was under the influence of drugs or alcohol or some combination of each to the extent that his normal faculties were impaired. Those kind of normal faculties that we need to operate a motor vehicle, the ability to see, judge distances, react to the circumstances and terrain around you. And what evidence do we have to prove the first part of that he was impaired? We have Skylar Smalley. She testified that everyone was drinking that night at the bar and at the after party, including this defendant. She also testified that when she came downstairs at about 4 a.m. at the after party, the victim and the defendant were in the kitchen drinking vodka. They had a bottle of Ciroc vodka, and we have a photograph from that night of the two of them with the bottle. Skylar Smalley testified that when she observed these two individuals in the kitchen, they were, quote, pretty drunk. And the defendant had at this point been drinking for about 7 hours to her knowledge, from the time of going to the club to throughout the hours of the after party. We also have Ryan Degg. He also said that everyone at the party was drinking. There was marijuana being smoked at the party in the form of what he called dab hits, some type of oil form of marijuana. Deputy Bragg responded to the defendant lying in a ditch. That's evidence of intoxication. He indicated that the defendant did not appear to have any injuries, but did appear to be under the influence of something. Bragg gave him a courtesy transport back to the Golden Park address. Eventually, we have Deputy Davidson, and Deputy Davidson told you that the defendant walked into the sheriff's office on his own volition in the company of his mother and gave a statement. He had no signs of intoxication, no signs of injury, no signs of blackout, and he gave a statement to her that he had been intoxicated the night before. He even wrote the statement out. And in that statement, he used the word to describe himself, intoxicated. Detective Revell interviewed the defendant, and he made several more detailed statements about the substances that he had consumed in the hours leading up to the crash. All of those statements are contained in State's Exhibit 38, those interviews. He talked about beer. He said he purchased an 18-pack of PBR beer that day and estimates that he consumed approximately 14 of those beers. And that brand of beer is corroborated by the fact that we have a PBR or Pabst Blue Ribbon beer shown in the vehicle after it's pulled out of the river. So that's evidence that corroborates his statement. Maybe he does remember things. Maybe he's not blacked out. He says he drank a few beers before the concert. He says he drank PBR brand beer. He said he had one before the sound check, a couple more after the sound check before going to the concert, and that he was still drinking at the after party, and he estimates a total of 14 beers that he consumed that night. He talks about liquor. He said he had 1 shot at the after party, but he later tells Dr. Pritchard that it may have been 2 shots, a shot of vodka and a shot of Fireball. He talks about Xanax, or the chemical name alprazolam. The defendant tells Detective Revell that he ingested Xanax at the club. In fact, he says, I wasn't drinking at the club because I was trying to be more responsible, so I just had a Xanax. He mentions 3 times in the interviews with Dr. Revell that he took Xanax, and he even describes how that drug compounds the effects of the alcohol that he was also consuming that night. He talks about cocaine. He said he did 1 little line and 1 little bump. He did cocaine right after he got back to the house. So that's about, based on the timeline that he gives, 1-ish. So if he consumed cocaine at that time, the expert testified that he would be in the crash phase of the cocaine. So he's not high or exuberant from it, but he's more in a depressive state at the time of the crash. Cannabis or marijuana. He talks about consuming marijuana as well. He said he smoked weed earlier before they went to Atmosphere. So he mentions all of these specific drugs in the interview. He can tell you when in the night he consumed them, approximately. He can tell you how much. He can tell you what kind, what brand, whatever you want to know about his substances that he consumed that night. He's able to remember all those things. And as I mentioned, the expert Stephanie Figueroa told you that if he consumed all the substances that he said he consumed along the time frame that he indicated, the results would be an impaired ability to see, to react to his surroundings, to multitask, and to perform the basic functions that one needs to successfully operate a motor vehicle. And even their expert, Dr. Pritchard, admitted that it would be a bad idea to drive a vehicle after consuming all of those substances. What else do you have to indicate that he was intoxicated to the extent that he couldn't drive a car? Well, his normal faculties were obviously impaired because he drove his car off a boat ramp. So you have to consider his behavior. And this behavior is also going to be the basis for your vehicular homicide charge, count 2. So his behavior is evidence that he was impaired. He took somebody home and doesn't recall doing it. You're hearing a lot about that throughout this trial as if it's something positive for the defense. He doesn't recall taking somebody home until he's prompted. And then he has one of those, oh, I was dancing on the bar moments and remembers, oh yeah, that's why I was out by Tower Road. I took Ryan Degg home. Well, that's evidence of his intoxication. And ultimately, he drove down Tower Road at dark or first light. That's the evidence we have with no headlights on. It's a dark area that's unfamiliar to him. He and his passenger, who is also intoxicated, are not wearing seatbelts. They have no idea where they're going. They pass a sign that says the pavement is going to end, and it does. That does not alarm him in any way to stop, brake, where am I, turn around, nothing. He keeps going 25 miles or 30 miles per hour, he estimates, down a dirt road, unfamiliar. Sees a dead-end sign or doesn't see it, ignores it, or fails to observe it. That's an indicator of impairment. And then just drives right in the river. Those are indicators of impairment, and that's evidence of the reckless behavior that is required for the vehicular homicide count 2. So, you've got everything that he consumed: beer, Xanax, liquor, cocaine, marijuana. No seatbelts, no headlights, not familiar with the area, ignoring the signs, not stopping. So, clearly he should not have been driving that night. So then the question becomes, was he driving? What's the evidence that he was driving? Is it a mystery that you guys need to solve whether he's driving, or really whether it was Jordan that was driving? Well, what evidence do you have? It was his car, number 1. Number 2, Ryan Degg saw him driving, and he lives, 1 mile, less than a mile from where the crash occurred. That's where he got dropped off. And when he got dropped off, the defendant was driving. There was no conversation about his driving being terrible on the way to Ryan's. There was no conversation about switching drivers. There was no reason to think that they switched drivers. Number 4, he told Deputy Davidson that he was driving. He hadn't forgotten who was driving due to blackout. He remembered and told the deputy he was driving. He wasn't being interrogated. He wasn't under arrest. He was there of his own volition, accompanied by his mother, who apparently did not have reason to believe that he was suffering from a head injury or a blackout, or was medically unfit to go up there and give statements to law enforcement. And he said he was driving that car and wrote it in a written statement. He also told Detective Ravel that he was the driver. In both interviews that you have with Detective Ravel, he talks about being the driver. He doesn't just say, I'm the driver. He gives specifics. I remember turning onto Old Bainbridge. She was telling me where to go. I remember Tower Road. I remember when it turned into dirt. And then, by God, that river just jumped right out in front of me. He says, I've never been down that road before. She done gave me directions, but she didn't say nothing about a lake coming up or slow down or nothing. So he was relying on his passenger to guide the vehicle or to give him instructions on how to drive this vehicle. Well, she was high and drunk. She told me to go right and go left, and then that's the end. I'm hitting the water. She was directing me where to go. I think I went right there, took a right out of Golden Park. I'm sure I was going probably about 25, I would say 30 maybe, because this morning, more than anything, that dead-end side, I damn sure messed up. I remember turning onto Old Bainbridge. He even says he thought he was driving okay, right up until the point he drove into the river. I mean, I wasn't drunk to the point where I was swerving all over the road or nothing. I mean, I was straight and in the lines. I mean, I remember that. From what I remember, I was driving fine right up until I drove into the river. The total times in that interview that he refers to himself being the driver, 10. That's just in the interview. It doesn't include Davidson. It doesn't include his statements to Skylar Smalley. 10 times in those interviews with Revell. And how many times does he say Jordan was the driver? 0. This trial is the first we're hearing of that. He wants you to ignore these statements because you have to. Either he wasn't drunk or he wasn't driving. Why would you ignore these statements? Because he was traumatized? Because he was intoxicated? Because being intoxicated, voluntary intoxication, as the judge read you, is not a defense. Even their expert told you, Dr. Pritchard told you, that you are most likely to get the truth in the first rendition. Skylar Smalley got the truth. Deputy Davidson got the truth. Detective Revell got the truth. He was the driver of that car, and he was messed up. He doesn't remember what state the windows were in. Does that mean he was blacked out? The most truthful statement is the first statement. It's going to be those statements to Skylar Smalley. That's the first thing he said to anybody. What did he say? Water. All I remember is water, and Jordan is gone. But he didn't tell the deputy that. He told Skylar that. He drove down Tower Road, and all he knew was he hit water. What else do you have to indicate that this defendant was the driver and not Jordan Nedeau? Dr. Flanagan says that Jordan's injuries are consistent with her being the passenger. Pat McLeod, the dive team guy, says when the vehicle was first raised to the point that he could peek in there and see her, her bottom half was over the passenger seat. I mean, she was floating. She could have been everywhere in that vehicle. But when he first observed her, her bottom half was over the passenger seat, consistent with her being the passenger, and her torso was slumped over the console area. When she comes to final rest in this position, does that look like a driving position? I mean, even then, we're just going to say, oh, she's in the driver's seat. But the problem with that is she's not in a driving position. So there's no evidence that she was the driver of the vehicle. And Brian Pfeiffer, the accident reconstructionist, says that the seat position in the vehicle is more consistent with the defendant being the driver. Could she have driven? Yes, she could have driven that car, but it would not have been comfortable for her. She would have had to point her little toe to touch the gas. And the defense wants you to ignore all of this compelling evidence that he was the driver of that car. Because why? Because he doesn't remember he had his window rolled partially up. Because there's a crack in the windshield. That proves nothing. She could have caused the crack in the windshield from the passenger side or the driver's side. Or it could have happened some other way in the wreck. I mean, this car was involved in a violent crash. It didn't hydroplane across a river. Anyone who's done a belly flop knows that water hurts. I mean, it doesn't hurt like a brick wall, but it hurts. And when that vehicle hit that water going 25 or 30 miles per hour, you better believe that there was a jolt. Loose items would be moving around the vehicle. Unrestrained occupants would be moving around that vehicle. And it's absolutely possible that she, from the passenger seat, impacted that window. It's possible that something else impacted that window and she hit the dash. But her injuries were not consistent with being the driver, because you would expect if she did hit the window and cause that injury from the driver's side, she would also have impacted the steering wheel, since it would be between her and the window. Is it possible that she could have flown over the steering wheel and just gotten her head? Sure. Anything's possible. Is it reasonable? And is it reasonable in light of all the other evidence in the case? That's the question for you. And when you look at all the evidence in the case, you know he was the driver of that car. Finally, for the DUI manslaughter count, I have to prove that his driving caused or contributed to the death of Jordan Nedeau. And the evidence has shown that after suffering a bad bump on the head, she found herself disoriented and alone inside that vehicle. It's not so unreasonable that she couldn't make her way out of there. She was on all those substances. She had a bad bump to the head. It looks like she was looking in the mirror because the visor is down and the mirror is open. And she probably really didn't know what hit her. And all of a sudden, water is gushing into the vehicle. She obviously did not have the ability to save herself, as evidenced by the fact that she's not with us. And it is the state's position that this defendant did nothing to help her. And I expect the defense to get up here and tell you that he did everything he could. He did nothing. And his own statement indicates that this young woman was calling out his name as that vehicle sank. He was the one person who had the ability to help her, or get help for her, or at least try to get help for her. He failed, and she died in that river with his name on her lips, with water gushing in all those windows. You can't just swim out a window. It's like drinking from a fire hydrant with that water gushing in. She maybe went toward the driver's side where he was already out on the other side trying to go out the way he went, trying to go to him, maybe trying to go away from the water. And he did not dive down there and try to pull her out. He doesn't know how he got out. He's 225 pounds, but he darn sure got out of there, didn't he? But he could not take her 90-pound frame with her. But okay, if he couldn't do it, if he was too high, too drunk, too pathetic to dive down there and pull her out of this vehicle, then get some help for her. Find somebody that can. And he was legally obligated at that time to render reasonable assistance. The defense wants you to believe that this man made reasonable efforts to get her help. The roof rack of that vehicle was only 12 inches underwater. How about reach down in there and pull her out? All the other windows beside the driver's window were down. Go in one of those. Pull her out. Is she unconscious? Did she get a mouthful of water? Pull her out. But he left her there to die. And he didn't make any effort at that point to try to get her help. He could have, and should have, and was morally and legally obligated to stop at that first residence down the road and knock on that door. Help, 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 I need help. What about the fire station? There was help there. He didn't get it. It's not a defense to be too high and too drunk to act reasonably toward other people. Each of us has a legal obligation to do that, and he had it too. And voluntarily getting drunk and high does not excuse you from that duty to others. Why didn't he get her help? One reason. Self-preservation. He was afraid of getting in trouble. He didn't want to get a DUI. Skylar Smalley confirms that. We knew what we had to do in the beginning. This is a quote from her testimony. We waited because he didn't want to get in trouble. He was reluctant because he didn't want to get in trouble. He was scared to call the police because he had been drinking and driving. That's not good enough. It's not good enough for Jordan Nedeau. He told you he ran until he couldn't run anymore, but make no mistake about it. He was not running to try to get help for her. He was running to try to save his own skin. He was running to try to distance himself from that scene. Are we to believe that he was too drunk or too high or too disoriented or concussed or blacked out to tell Deputy Bragg, if not someone sooner, hey, I drove my car into a river and there's a young lady that might still be in there, might be injured, might be hurt, might be dead. But he was well enough to run 2 or 3 miles from the boat ramp to where Deputy Bragg found him. He was oriented enough to recall seeing the Benson Heat and Air sign, but he wasn't well enough to knock on one of those doors and ask for help. He wasn't well enough to stop at the fire station and send help for the young woman drowning in his vehicle. But he was well enough to come up with a story for Deputy Bragg about how he came to be there in the condition that he was, lying in a ditch without his car. He wasn't confused when he made those statements. He hadn't been separated from his friends the night before, and he hadn't had his car towed. He was trying to make up a reason why he was out there because he didn't want to get in trouble. And he was. This is the law. This is count 3. He was legally obligated to report the crash to the nearest office of a duly authorized police authority. Well, I think a cop in a uniform in a marked patrol vehicle talking to you and taking you home counts. And he ought to have said something to Deputy Bragg, and he knows that. He said he ought to have. He had no excuse for it. He wasn't confused when he was in Deputy Bragg's vehicle. And that's evidenced by the fact that as soon as he got home, he told Skylar Smalley he collapsed in a puddle. He was freaking out because he knew he had done something bad. His failure to save Jordan, or to at least try to send help for her, is a crime. And it's not lost on anyone in this courtroom that this defendant sitting over here is a young man. And this is a tragic case that has destroyed more than one family. But he is an adult, and he has to be responsible for his actions. And blaming the victim is not a very good start. All the evidence points to him. He's guilty of everything he's charged with. And as such, I implore each and every one of you to vote for a verdict of guilty as charged. Thank you.
Thank you. Mr. Jansen, are you doing the closing? Oh yeah. Good morning, ladies and gentlemen. It is an easy case. He owned a car. He was seen driving the car earlier. And he made some rambling statements, inconsistent statements to the police, but he thought he was driving. That's it. We spent 2 days. That's all we have. That's right. There is evidence. There is a burden. There is physical evidence. I didn't hear any of that. Zero. We want to rely on statements from a bunch of drunk teenagers. Many of them were smoking, using drugs, passed out, don't recall. But that's how they prove impairment. By other impaired people. Interesting. I told you in the opening that there is a mystery who the driver was. The injuries, how did the car and how did her body get out of the car? Who removed the car, the body? And what condition was that car in before anybody did any tests on it? They could be sitting a Parkway towing company, a bunch of old guys out there selling parts, drinking beer, eating lunch in the car. We don't know. There's no evidence how that car left the scene in the river. And then 10 months later, Dr. Pfeiffer, this high-priced guy that basically used a tape measure and got $10,000, whose figures weren't even accurate. How do we know that the guy that moved the car didn't get in there and adjust the seat? What contents were found in the car? Who was the investigator that investigated and said, I can't find DNA? Well, we know it wasn't Davidson. She's off duty and patrol. We know it's not Bragg. And we know it's not Bill Revell who said, I'm a homicide guy. Or no, he said, I'm a violent crimes investigator. I don't go to do that. I basically took an interview. It's a sign, he said, that traffic homicide. I don't recall a traffic homicide investigator coming in here. Oh no. We had the retired traffic homicide guy that came, in that the state tried to make him look foolish. A man who dedicated his life to law enforcement, dedicated his life to investigating crimes and solving murders, who said, I would never charge somebody without evidence, putting him in the seat. I wouldn't charge anybody without proving they are impaired. What did he do? Well, he went and inspected the car. He got in the car, he's 6'3", and got in the car. What did he find? He found a broken rear view mirror. What did Davidson? Did she find the rear view mirror broken? No. Did Bragg? No. Did Revell? No. As far as we know, Pfeiffer didn't even see it. We had to show him the picture. Ask yourself, why is that important? Because if there is a crash in a car, if it is outside or inside water, people are going to get injured. And if you don't know who the driver is, and you want to prove beyond a reasonable doubt who the driver is, you do an investigation. Who had injuries? Jordan Nedeau. Where was that injury? Her forehead to her right eye. Her own doctor, the medical examiner, her right eye could have hit something. If she's in the passenger seat, her right eye didn't hit the rearview mirror. If she's in the driver's seat sitting up, and that car hits that water, she hits up. She hits that right eye on the rearview mirror. Ignore that because he owned the car. He was seen earlier driving and he partied with some of these people, so that makes him the driver. Well, how did he get out? Their own witness, McLeod. Who had the hardest time getting out of that vehicle? The driver. Why is that? The door won't close. Can't latch him. Can't latch when it goes in water. It was lodged against a tree, and the window was 3/4 up. Who had the easiest chance of getting out? Anybody out both windows? How do you think that Mr. Rushing got out? Through the windows. That's their own witness. They want you to believe that a man, Mr. Rushing, who, by their own witness, Mr. Dagg, if you recall Mr. Dagg, he was the man who kind of led this whole thing because he lost his keys. And because he didn't want his girlfriend, who's pregnant, not to see him in the car with a beautiful young lady. Says, park the block away or 200, 300 feet away from the house, so my pregnant girlfriend won't see me in the car with a beautiful girl. She was a beautiful girl. He didn't see where they went. He didn't know where they went. He turned around and had his own issues to deal with at home, and he wasn't looking back, and he wasn't admitting anything. Well, what did he say? He said he was there. He said they ate some chicken. He said he may have used some weed. And he said when my client drove him, he was fine. He wasn't impaired. He didn't wreck. The curious thing that is funny is that they want you to believe Mr. Dagg's testimony put him in the car, but they forget. And they haven't even realized that the directions Mr. Dagg said they went to his home are completely different than what my rambling client said to the police that night. They didn't even go the direction that Mr. Dagg said they went. Is that another deception contrived by my client to find some weasel way out of this? Or is it because my body has suffered a traumatic event, may have been hit on the head, may have had alcohol and some of these things, but doesn't recall, did not recall? And maybe he did suffer a blackout, not a pass out, a blackout. Blackout is not some phase you're walking around blacked out. It is inability to encode, to remember events that occurred. So none of these, Cecilia Davidson is not going to know if he suffered a blackout. It's not an active thing that you can visually show. It is your inability to remember what happened. So when he's at the police station, he's there reporting his car missing, trying to find Jordan. He's found in a ditch, and we don't know the route he took. We don't know how he got into that ditch, but we know he got in the ditch. We know he got out of the vehicle. But what we don't know is what happened. What happened? Where did they go after Mr. Dagg ran home to his girlfriend, his pregnant girlfriend? What happened? Who really knows? You want to rely on my client who can't remember? He couldn't remember what water they were in. He had to be told by a neighbor who said, "Oh, that's Tower Road." And they drove out there 2 and 3 times. And then he seen the road in the daylight. And as Dr. Pritchard, who's an expert in this field, said, sure, when you have a fragmentary blackout, as you see things or hear things, your memory starts to pick up, and then he realized maybe you're remembering that road. That road. Shocking that the case was assigned to a traffic homicide guy. But yet, this violent crime guy, Mr. Revell, this week or late last week, drives out the Tower Road and takes pictures of road signs and tells you that they were there in 2014. They weren't even there. Why? We know why. It's called the scramble. The state introduced exhibit number 36, which has no relevance to this trial whatsoever, except it will show what a dangerous road this was. You see this? The curious part about this new sign is look at its location. Okay, look how close it is to the road now. And then look at the next part that says 500 feet ahead. That gives you a description that the dead end is 500 feet ahead. That's fair. Probably could add water, but I don't know. There must be a tight budget. But let's show you what it was like in the night in question. Whoa! I don't even know that's a legal sign. That looks like a private person's sign that says dead end. It's got to be 20 feet off the road in the bushes. It's summertime. Vegetation could have been half covered up. We don't know when this picture was taken. And look, no 500 feet. Is there? Is there? It doesn't tell you. All it says is it's a dead end. That is evidence. This is not. The cracked windshield, we introduced photos of the cracked windshield. Didn't make it up. That's a crime scene. That's evidence. That's what this verdict should be based on, evidence. Who cracked the windshield? Who cracked the windshield? Well, you saw my client was seen by Officer Bragg. Any injuries? Nope. If he hit his head or was bleeding, that would have been seen. Clearly, would have been visible. He said when he came upon my client, he was disoriented, fidgety, no deception, no odor of alcohol. He wanted to know if his car had been towed. Interesting. He was disoriented a tad bit. Now, he wasn't a marksman act, because if you are drunk and a danger to yourself or others, they can arrest you. He didn't do that. He didn't let him walk home because he was so disoriented that he was a danger to himself. So what did he do? He did the unusual thing and called his supervisor at 9:30 and said, "Hey, can I give this disoriented guy who's confused a ride home because he was walking down the road?" Is that deception and confusion making up? Or is that actually what happened? And Dr. Pritchard said he was just in a traumatic event. The car goes underwater. He gets out. He's hit his head possibly. He sees his friend in there. He can't get her out. He gets out. He's exhausted and he has a blackout. He passed out. But when he woke up, he was suffering a blackout. There are two different things. So, when he came upon the officer, he couldn't remember Jordan in the car and the car where it was. Naturally, he didn't tell the officer. He gets back and sees Skylar. He walks in and says, "Where's my car? Where's Jordan?" And starts crying. He doesn't know why. Doesn't know. That is when someone says, "Where were you all?" And they describe the road. And they go, "Oh, that's got to be Tower Road." They're now trying to help him encode what it was. And that is the first time that they call memory assist as being done when he walks into Skylar's house. People that were there start to tell him, piece together those snippets of what happened the night before. Who knows what else they were telling him? They're probably going back saying, "You did this, that, and that." And that's encoding his memory. How does he know what is true and what is not true? So I asked Dr. Pritchard, could they get information wrong? Sure. So did he know at that point that he was on Tower Road and she was at the bottom of the lake? The evidence is no. So what do they know? They call hospitals. They try to find out where the car is 2 times. They go down to the landing. The first time he says, I'm not sure this is it. He doesn't have the recall the first time. They don't see the car in the river. They go back, and apparently then they make some more phone calls. And then they decide, or he decides, contacts his mom, and then they go to the police station on his own. Mom didn't get a lawyer, didn't say, hey, what you did, we better get a lawyer. Don't make a statement. No. Mother, father, grandfather go to the police station. They go to the duty station to put a missing person out, to put a missing vehicle out. And while they're there, they meet Miss Davidson, relatively young, relatively inexperienced patrol officer, friendly enough, but says he wasn't making sense. He was a bit confused, of course. She's not going to recognize if he suffered a blackout. She had never encountered this guy. She didn't even know what happened the night before. She's looking for a car, but she's not going to spend resources if they can't get more information. So he gives a written statement, and it's curious. Inside the statement himself again that he gives, he can't recall. He writes in the statement, I don't remember. Oh, I'm sorry. I have very little recollection in his written statement. And this is 9:30, 10:30. I have very little recollection, but yet the state wants you to believe, oh, you should believe everything he says, even though he says he doesn't have recollection. Or whatever he says that benefits him, disregard. Anything that possibly hurts him, you can believe that. And we don't need to do an investigation. It doesn't work that way. We don't convict people. People going to the police station and saying, people say all kinds of things when they go in there, but it is not true. People believe in the mind is a wonderful thing, and sometimes it can be an awful thing. People believe and feel they see things or done things they really haven't done. So that's why we rely on evidence, on investigation, law enforcement that's trained, traffic homicide, people that are supposed to be specifically trained to investigate, document, bring in evidence. And it was really puzzling because she wasn't really involved in the whole case. And then she got off duty. And then someone called her while she's off duty on her personal phone to tell her that the window on the driver's side is up. And why is that important? It is contrary to him being the driver, contrary to his statement, contrary to their little pattern. He did mention that what facts are important. Air conditioning, he always rides with his windows down. His mother testified to that. He said it multiple times, no AC, and it's August. Everyone knows, common sense, August is hot. Skylar comes in, admits that she was out of it, that she went to bed, really never saw them drinking. There's a photo of a full bottle of whatever you want to call it, alcohol. We assume it's alcohol. Again, we make an assumption. It's a bottle. It's in a bottle. It wasn't opened. It wasn't tested. They didn't bring you the empty bottle. They showed him holding up a full bottle. He couldn't recall what happened with Davidson. He couldn't recall with Skylar. So, as the time is going by, they're going to have you. He's completely making this up, and he's so deceptive that he's able to fake and not remember some things and remember others. And he's keeping this going while at the same time he's trying to figure it out. At the same time, he's trying to figure out why his windows were up. Even Pritchard, when he talked to him later, said, "I can't rectify why the windows were down if I was driving. That wouldn't be accurate." Fletcher Vaughn came in and basically said he was drunk. He partied. He passed out and can't recall anything else. Doesn't remember anything else. And he didn't take marijuana. Can't testify about my client's impairment at 7 a.m. Skylar cannot testify about my client's impairment at 7 a.m. She wasn't in the car. She wasn't around. She didn't even see him driving. So we still have two witnesses that can't testify to any impairment. Unless you want to guess and say, okay, if the guy had some drinks, he had to be stoned, had to be high, and he must have been impaired. That's not the standard. That's not the standard we have here. Ryan Deggs, he testified that he drove fine. He contradicts the impairment argument by the state. He contradicts the impairment argument by, well, I would say witnesses. There are no witnesses that said that my client was impaired when he was driving, if he was driving. And we still don't really know where they went after Deggs. We don't know if they actually went and got the cigarettes. We don't know if they turned down another road. We don't know if they switched places and Jordan got in the car, and that's why she rolled the windows up 3/4 of the way. We don't know that. And the evidence is going to be proof beyond a reasonable doubt by a conflict in the evidence. Lack of evidence. Deputy McLeod, I think, was a good witness for the defense and a good witness for Mr. Rushing because he said he has never ever seen a car door, once it goes in water, once it is open, shut and be completely latched. The pressure is too much. You cannot completely close it. I defer to his expertise because he's on the dive team. He's probably uncovered lots of vehicles in the water. This car, the door was completely latched, completely closed, and not half opened. No one exited through the door. He indicated that he did see windshield damage. He didn't know what caused it, but he noticed the windshield damage, not from the outside, but from the inside. And he said they pulled it up and he took some pictures. Now, the water was awful murky, and he tried to say she was not in the driver's seat. Her body was in the passenger seat. But then, upon cross-examination, I asked him, well, when the water is going out the window, wouldn't that push her towards the passenger's seat? And he said, yeah, it would. So, more likely than not, she would probably be more left than she was more right. But the problem we have, internal compartment of the vehicle was never really inspected. No contents have been introduced in this case, except they appear to be a billfold in the back seat of Mr. Rushing. We don't know how the vehicle left the river there. Ockaloochee River, there on Tower Road. We don't know where it had been stored. We don't know the condition. We don't know if it was dried out. We don't know if any witnesses or any techs tried to go in there and CSI to try to get any DNA. We know that Mr. Crawford went in there and saw some things. And he's testified he may have been a little older, maybe a little more experienced, but that doesn't negate his experience. You don't need a college degree at some fancy college with some big bills to know how to conduct an accident crash scene. I think he was candid. I think he was honest. And I think he's got more experience than all of us put together doing a crash investigation. He went in there. He said you could possibly get DNA. You can possibly get fibers once the car is dry. And if somebody hit the rearview mirror, you possibly could get hair fragments and blood. We don't need that evidence. He owned the car. He was earlier seen driving, and he made some statements. Why bother with evidence? Even if her injuries are consistent with hitting her head in that location on that side, and her body is found on that side, and she didn't get out of the vehicle because that's the only window that's up, just ignore that. He had to be driving, of course. This is a guy in his interview that can't recall whether he had sex with her that night. Not that I recall. I don't think so. I think he would remember that if he did. But when he says, I can't recall that, he probably can't recall much. So we really don't know if the track seating is actually... Let me read that part again. This is a guy in his interview that can't recall whether he had sex with her that night. Not that I recall. I don't think so. I think he would remember that if he did. But when he says, I can't recall that, he probably can't recall much. So we really don't know if the track seating is actually in the same position that it was at the time of impact. We don't know that. Mr. Pfeiffer, interesting. Mr. Pfeiffer, he gets retained and listed as an expert. I think he was retained in March or April. He says he did 10 hours. Went to the crash scene June 16. I think he said it was. So from August 2014 to June 2015, we have no information, no evidence about the car, where it was stored, the condition, who went in it, who went out of it. We don't know. We don't have any evidence. So all his test results are flawed because there's no complete linkage chain. Normally, a custodian says, this is what I did. I did it here, then I did it here. I collected this. Nobody touched the car. Nobody went in the car. We don't have that. We know 10 months later, this guy with his kinematics, which is a fancy for a measuring tape, measured. And then he did his measurements. He really didn't do much investigation. He relied on some figures that were wrong. He had my client at 5'8". His original test, my client was 5'6", 5'6" and a quarter. He found that out Monday. The victim was a little taller than what he thought, maybe a half an inch, 5.5. I heard Flanagan say that her leg, hip to leg, was 35. I will defer to your notes, but I thought she said 35. I know that he said that my client's hip to ball foot was 35 also, exactly the same. Asked about arm length. We don't need to consider that. Mr. Commissar cross-examined him, and I felt bad for Mr. Pfeiffer after a while, because the more questions you asked, the less answers you got. Then it got to a point like he didn't have a figure or didn't have his measurements. It wasn't going to change his position. It wasn't going to alter his experiment. Even though we know that we don't all sit and drive the same pattern, some people likely have theirs on 10 and 2. Some people like to do the one wheel. We have people that try to drive low. We have got people that sit up. We've got people that sit back. And some people tilt the wheel. The tilting of the wheel was the real thing. You tilt the wheel and it puts you all the way towards who the potential driver can be. Some people tilt the wheel so they don't have to move their seat. Some people don't know how to move seats in these cars these days. They're fancy and hard to find. Valet people move cars all the time, and they don't move the seats. But they do, and somehow, magically, the seat is in the same position it was when I dropped it off. So Pfeiffer got paid $10,000 approximately, or he's going to get $10,000. He bring these two people in, and when he put two people side by side, the one guy's leg is left hanging out of the car. It kind of reminded me of when I went to the fair many times. And the guy climbed that little rope. It makes it look easy. And they get you to do it. And then the next thing you know, it looks a lot easier than it is. It looks like it is so simple, this theft, but in reality it is not. It is flawed. So all these investigators said they were in different unit. Bill Revell said all he did was, one, he introduced the wrong sign and he took statements. I asked him, why didn't you, he voluntarily came in at 7, why didn't you take a urine or a blood sample? I don't know. I didn't think about it. Okay. The body was found later. Why didn't you take a blood sample or urine sample? I don't know. I'm an investigator. It's what I'm trained to do. It's what I get paid to do. At 2:45 or something, then they finally get around to it. And now they want to penalize my client for saying we failed to collect any investigation. We failed to collect any evidence. But you know what? It was probably there. So we're going to call somebody to come in and say it probably was there. But it is not. Alcohol is not there. Cocaine is not there. Xanax even. If it is there, it is basically not there. And the marijuana, we don't know when it got there because of the life before or after. We know she's impaired. She has cocaine, Xanax, marijuana, and a 0.7 alcohol content in her. He has nothing scientifically to prove that he's intoxicated. There's not one law enforcement officer to come in here and say he appeared intoxicated. So what do? Ignore it? Just believe their theory? Believe what he said? Believe that these drunk people who were intoxicated, high, doing drugs, just believe them? That's the element? I don't think the jury instructions are going to say you can believe the impairment based on other impaired people. That's probably not a good measurement. They jump to conclusions and want you to believe it is his car. Mr. Degg's house. He made these admissions on and off. Somewhat. Wasn't driving. That's enough. We've done it. Finished. He's guilty. All the elements are satisfied. Don't look here. Ignore this. Ignore that. Pfeiffer did no test on injuries. He didn't look at the head of the woman. He didn't say, okay, the rear view mirror. He went to the scene. He did an accident reconstruction. Never in a submerged car case tried to make a big deal about that. He didn't say anything about, okay, what broke the mirror. He did admit the closer you are to the steering wheel, the less likely you will get steering wheel injuries in a crash. Because you don't have that indicating. You have that if you're holding on to the wheel. No one checked Mr. Rushing for steering wheel injuries. If he's driving the car and it is so back and he's sitting back there and he hits, where is his injury? He's at the police station at 9 in the morning. He's back at 4. He's there until 11. Take your shirt off. Where's his head injury from hitting the rearview mirror? Bill Revell said he was confused, disoriented. Didn't know what a blackout was. Not familiar with it. Wouldn't recognize it if he was under it. Absolutely agree with all that. I don't recall. He said, I don't recall many times. He mentioned the windows and mentioned the AC problem didn't work. He said he wasn't drinking at the club. My client told him he wasn't drinking at the club. Some of these other witnesses, oh yeah, he was drinking at the club. Which is it? And I explained to you, and look at your notes. Look at your notes if you have notes. You don't have to take notes. But ask yourself and look and see what Deggs said when they got to his house. See if it is anywhere near consistent with what my client allegedly said in his rambling statements. So why the contradiction? Maybe because he's trying to figure out in his own mind what happened. Maybe when he's sitting with the police, he's trying to figure out and piece together these snippets of information that people are giving him. Where he was, what he did, what body of water. Maybe that's what he's recalling in this interview. And it is not coming together. He doesn't know how he got out of the vehicle. If you're going to make up, I wasn't driving, she was driving, or if you were going to deceive them in any way, wouldn't you just say, I climbed out? I swam out the window? Wouldn't you say, oh, she was definitely driving if you were going to make stuff up? Or maybe he's telling the truth and he doesn't recall. He told Pritchard, Dr. Pritchard, in his interview, he couldn't recall. He thought he might have been driving. Maybe he wasn't driving. And then I asked Pritchard about maybe survivor's guilt or hero's guilt. Maybe I didn't say survivor. Maybe I asked him about hero. Did he want to be a hero? And maybe he's feeling guilty about what happened and feels bad about it, so he's taking responsibility. But the facts just don't fit together. If you really dissect it and you really want to look at this case and the evidence, the facts don't fit. If you want to just go by his rambling and say, oh, he admitted that, everybody's wasting their time. But how do you, the juror, fit that with the evidence which tells you he wasn't driving? How do you do that? I'm glad I don't got to do it. Independent corroboration, law enforcement corroboration, scientific evidence. We don't have none of that. Dr. Flanagan, I think her basic job is to determine how people die. And that's a good thing. That's a really tough job. That's a horrible job. I would never want that job. Thank God she's doing it. And she didn't go out to the crime scene. She's not an accident reconstructionist. Her job, she's a medical doctor. I'm sure she hasn't been to any seminars. She's doing what you would expect her to do. Look for injuries to the body. Figure out the cause of death. And then try to figure out if she can medically fit the facts to the car scene. She couldn't. She couldn't tell you. She's not sure. Her right eye could have been hitting something. That's her words. She could have been driving, possibly. She could have been a passenger, possibly. Could she have wrecked that car without having chest injuries? Could have. We know she wasn't wearing a seatbelt because there would have been that. And even Pfeiffer said if she was real close, she wouldn't have those chest marks. But the scalpel injury and the head injury are the puzzling thing, because when the car went in, it's not like it hit a wall. Okay, Crawford will tell you when that car hits water, it kind of goes up. And that one is going to go up. It's not like hitting a wall where you go forward. And he clearly said her head did not hit the dashboard unless she was in the back seat and the car goes forward. And there was no evidence of any damage to anything to the dashboard or on the passenger side. That's coming from the only person who went in the car and has years of experience, volumes of cases and experience. He didn't take great weight in the location of the seat because anybody getting in that car can drive that vehicle. You don't have to move that seat. Now, if you're going to drive to Miami or if you're going to drive for a couple of hours, you're going to adjust it and adjust the rear view mirror. But if you're just going somewhere and you switch places and you're going a short distance, you're driving. You jump in there and you're driving. You manipulate your body to the car. And he doesn't rely on that because he's got experience and he knows. And so what he looked at was the injuries. He looked at that and found, and he gave you a reason why. He told you why that cracked. He told you why that crack spread. He told you where it was. That's what he told you. He told you that that car wasn't going very fast. Because why? There's no front end damage. Not enough damage to that front end. There's hardly any damage. He believes that damage to the right front was pulling, dragging it out. Our expert testified to that, not based on some drunk kids or rambling statements by someone who suffered a traumatic event. Who's more likely to drive in the lake? Someone with a 0.017 blood alcohol, or someone that we don't even know what his level of impairment was? Driving a vehicle that she's not used to, driving it in a car where the seat may not be adjusted perfectly, and who may not have been able to get out because she was in the driver's seat, and whose body was found in the driver's seat. He's pounding on the driver's window. Why is he pounding on the driver's window? Because she's in the driver's seat. If she's in the passenger seat, she doesn't need to pound on the driver's window. So if you want to believe all his statements, you have to believe all of them, not some of them. You can't find it both ways. Dr. Flanagan said that she died from drowning. She did not die from the car accident. You want to believe what he's saying? She was still alive after the car accident. Her testimony, scientific testimony, was she died from drowning, water in the lungs. I submit to you, she did not drown because of that. The state would have you believe she's just sitting there impaired in the passenger seat with the window down, and she did not get out of the vehicle. The window is down. She weighed 100 pounds, relatively small, could have easily gotten out of the window, but her own voluntary impairment. And the government's theory, or the state's theory, would be that my client climbed over her, or climbed and swam in the back seat and swam out a window to get out of the vehicle, since their own expert, MacLeod, said the door could not have been closed. How else did he get out? He had to get out a window. Much easier if he's sitting in a passenger's seat. Get out the window. Go back to if you listen to his rambling statements. He's trying to refresh what he did the night before. And if he did really all the things he said, there would have been some drugs in his system. There would have been some alcohol in his system. If he really drank 14 beers, 2 shots, cocaine, there would have been something in that system. The system doesn't lie. It didn't lie in Jordan's case. It showed she was in her what was in her system. Dr. Pritchard is a very serious man, very serious witness. He doesn't add or subtract. He tells you what he thought. He answered your questions, answered my questions, answered the state's questions. He's been studying the mind, alcohol, trauma, and he knows what a blackout is. And we tried to get him to explain what a fragmentary blackout is, inability to recall. It is not made up. It is not junk science, and it wasn't. I wasn't at the scene. I wasn't there with him when he came out of the water and told him, "Pretend like you don't remember what happened." There's no evidence he talked to any lawyer before he went to the police station. There was no evidence he ever talked to any legal counsel. He went down there voluntarily, trying to figure out what happened. He was trying to recall what happened. And he said, "Pritchard, he may have gotten it wrong. Some may be wrong. Some may have been right. So what do you do with that? How do you parse out what's right and what's wrong? Is that beyond a reasonable doubt? Is that the standard the court read to you? The presumption stays with the defendant at every stage if it is overcome, unless it is overcome by evidence, to the exclusion of every reasonable doubt. Is there doubt who was driving the car? Absolutely there's doubt. We have got 2 or 3 witnesses saying she's driving. Was he impaired? We still don't know. We would be guessing. Is that road dangerous? MacLeod said he's pulled 3 cars out of there. You saw the signs. Dead end. Dead end to what? At nighttime? Dead end? Right in the water. No evidence of speeding. Nothing at all. No evidence of driving erratic at all. I told you this was a difficult case, and it is a mystery because when you look at the evidence, you listen to the experts, you look at the science, we don't know who was driving. The state wants you to say, "Oh, he was driving. He said he was driving. He had to be driving. Yeah, he was driving. He was driving earlier. He's got no injuries. No one puts him behind the wheel. No one knows where they really went. He gets out. She doesn't. She has injuries. He doesn't. And the injuries are consistent with who was driving the vehicle. She's found in the driver's seat. He gets out of the car. Tom Crawford, Florida Highway Patrolman. We love Florida Highway Patrol. If I can't put him in the seat, and if I can't make him the driver, and if I can't prove he's impaired, I'm not going to arrest him. It would come back on me. 37 years experience. He supervised every traffic homicide for Florida Highway Patrol for the last 14 years. He himself was a lead investigator on 360 fatalities. 360 too many. This was not a violent crash in her closing, the prosecutor. This was a violent crash. A violent crash would have deployed airbags. This was us right into the water. The airbags did not deploy. There was no damage to the front end of the vehicle. The only damage was the rear view mirror inside the vehicle. The mother testified that the crack was not in the windshield. The mother testified that he always drove with the windows down. That's a fact you need to look into and say, how does that fit? How does that fit in this little puzzle if you're going to look at the puzzle? If you're going to put the puzzle together? Or if you're just going to go in there and say, well, they said it, he must have done it, he's here, and that's what we do in our country, that's not what we do. And that's not what you said you would do when you took the oath. You were going to base it on the evidence. Now, you don't have to accept all the evidence. The judge is going to tell you the evidence as he read the instruction. Conflict in the evidence or lack of evidence, that's the problem with this case. There's a conflict in the evidence, scientific evidence, and there's a lack of evidence to prove he was driving and driving impaired and caused her death. Clearly, there was no reckless driving. Count 2, there's absolutely nothing to suggest that he was driving in any reckless manner on a dangerous road at night. And the vehicle basically just went going straight. Count 3, leaving the scene of a crash involving death. Now, the interesting thing is on that count in element 2, you're going to hear Jeffrey Rushing knew he was involved in a crash and had a duty to report it to the police. Not what he knew, not what he knows now, not what he knew later, but at the time of the crash. What did he know? And all the evidence suggests, from Bragg to Davidson to Schuyler, he didn't know. He didn't know where his car was. He didn't know where Jordan was. All he could recall was water. He voluntarily went to the police station on his own. He voluntarily stayed at the police station on his own. He's picked up and given a courtesy ride because he's so disoriented. Is that knowing? And did he have an obligation if he didn't know it was the time he got out when he first had contact with the police? I would suggest to you it is not. It is consistent with what Pritchard said. He suffered a blackout at that moment. He didn't realize what really happened. And it was a traumatic event. Willfully means knowingly, intentionally, and purposefully. In regards to his statement, the judge read to you instructions on how to take his statement. Once again, on page 8 of your instructions, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. Knowingly suggests he had full capacity, all of his resources understood, were able to, with clarity, to know what he was saying. I suggest to you that Pritchard reviewed his statements, Pritchard interviewed him, Pritchard said he was suffering from a fragmentary blackout, and Pritchard said it is hard to figure out what to believe or what not to believe. I suggest to you, ladies and gentlemen, what you should believe and what you should rely your verdict on is the evidence. What physical, scientific evidence has been introduced. And I submit to you that they have not proven beyond a reasonable doubt that he was the driver. They have not proven that he was impaired. They certainly haven't proven that if he was driving, he did it in a reckless manner with intent to kill her or harm her. Probably he went straight in the water. And they haven't proven that when he got out, after being passed out from the traumatic event, that he wasn't suffering from a blackout. And he knew he wasn't a crash. He's a young person. The young lady in the car was a young person. There's not an easy case for anyone. But we require proof beyond a reasonable doubt. Beyond a reasonable doubt. Ladies and gentlemen, we can't bring the young lady back, but you can't penalize him because law enforcement failed to do any investigation, failed to collect evidence that would have exonerated him, and just say he don't own the car, he was earlier seen driving and he made these statements. That's not enough. It is in conflict with all of the other evidence. You're going to do the right thing because it's not easy. But as long as you base your verdict on all the evidence, not just statements, but on the evidence, you're going to have to find him not guilty. And that's going to be hard. But that's what your oath is for, on the evidence. Thank you, Your Honor. Thank you. Rebuttal argument from the state?
Yes, Your Honor. Did he say 2 to 3 witnesses said she was driving? What we say is not evidence as lawyers, and the judge will give you an instruction about that. So what Mr. Jansen says is the evidence. That's your decision. We each tell you what we think it is. What Mr. Jansen says about what usually happens in other trials, that's not in evidence. Focus on what's before you, and you make the decision. Is it enough? Oh, we only have him driving the car and admitting that he was driving a car, and we only have him admitting that he was drunk and other people seeing him drunk. That's not enough. Well, that's your decision to make. Reasonable doubt. When you're deciding your verdict back in the jury room, reasonable doubt. It's not just a possibility or speculation. If you're back there saying, well, it could have been this whole other thing that there isn't any evidence of, but it could have been, that's not a reasonable doubt. You have to be able to attach a reason to it. It's not anything that's possible or anything that's speculative or anything that you could come up with. All these wild, possibilities we've been talking about. Counsel said something really interesting in opening statement, which I wrote down. I don't remember if you all remember, but he said the mystery bit. And then he said the driver of the vehicle is the one that's responsible. And he went on to say, there's not going to be any evidence that my client was the driver. But I do agree with him that the driver of that vehicle is the one that's responsible. But aren't we saying something else now in closing argument? Didn't we just hear that lots of other people and other targets are responsible? And he went on to say, that's not going to be any. And he went on to say, there's not going to be any evidence that my client was the driver. But I do agree with him that the driver of that vehicle is the one that's responsible. But aren't we saying something else now in closing argument? Didn't we just hear that lots of other people and other targets are responsible? The cops are responsible. They did a terrible job. The county sign people are responsible. They didn't put up a good enough sign. The witnesses are responsible. They're all drunk and high. You can't believe them. Well, they're his client's friends. I didn't pick them. They didn't say he was drunk. Well, I disagree. You rely on your memories of the evidence. My recollection is that Skylar said they were drunk in the kitchen. Fletcher Vaughn said that they were drunk and had a conversation at the bar about, I drank more than I should have and smoked. Maybe a blackout is to blame, not the driver. Maybe an expert is to blame. Dr. Pfeiffer charges too much. He doesn't know what he's talking about. He's only got a PhD in engineering. He's fancy. But our expert, you should believe, Mr. Crawford. I'm not going to talk about Mr. Crawford, and I was not trying to humiliate him. But this is a court. If you're going to say something, have a reason. Have something to back it up. Dr. Flanagan, you can't trust her opinion because she's not an accident reconstructionist. Well, no, she's not. She's a medical examiner who's done, thousands of autopsies. So she knows what injuries are. She investigates deaths. She determines causes of death, not just medical stuff, but forensic stuff. She works on criminal cases and makes determinations about how people die. Her opinion was that the victim was on the passenger's side when that crash occurred. And finally, aren't we blaming the victim? She was the real culprit. She's the driver. Well, unfortunately, she's not here to tell you what happened to her that night. But the evidence in this case speaks for her. She was on drugs. Well, yeah, she sure was. And it's interesting that everything in her system is the same stuff that he says he was on that night. And that's like taking a snapshot of what they were up to. Because when she died in that vehicle, her body didn't process those substances anymore. And it gives you a clue. Not necessarily they took exactly the same thing, but it is interesting that she's got cannabis, Xanax, cocaine, and alcohol. About double what the legal limit would be of alcohol to drive. But she's not on trial, folks. She's not to blame. So we've got all these other targets or diversions that the defense is talking about in closing argument. But none of these things are to blame. None of these things get it right. What got it right was the opening statement. The driver of the vehicle is the one that is responsible. And he even said something in closing that I agreed with. He said, this was a beautiful young lady. Well, she sure was. Just absolutely so full of life, she could jump off this page. And due to the actions of this defendant and his choices that he made that night. And that's what this case is about. Him. This is what became of her as she gasped for air in that vehicle and drowned alone and scared in the dark. And there's only one person responsible for that. One person's choices that led to that. She didn't kill herself. The crash killed her. She drowned because the crash was in a body of water. He is responsible for his actions. In the event that you get back there and you think you might have a reasonable doubt, please listen to the statements again, because he does dig his own grave with those statements. That's why the defense was working so hard to get you not to listen to them. Statements like multiple statements about being on the driver's side and never going over to the passenger's side. Statements like, defendant rushing, I'm almost 100% positive. Well, he's asked, and you're sure it was Tower Road? Answer, I'm almost 100% positive. I give it like 98. If it's not that, it's an extremely similar setup, and they were telling us about the only thing like that out there. Sir Ravel, what do you remember from last night other than the dirt road? Do you remember any other landmarks, any parks, any buildings? Answer, yes, sir, I remember. I knew I was on Tower Road because it was Benson Heating and Air. I specifically remember, so that's how I knew I was on the right road. And statements like this, Sir Ravel. Well, was she intoxicated? We all were. Everybody. Sir Ravel. Too intoxicated to drive? Why didn't she drive? Why did you drive? Defendant rushing. She didn't drive because she's smart, and I drove because I'm a dummy. That's all there is to it. You were too drunk to drive? Well, any drunk is too drunk to drive. Don't ignore those statements. Don't ignore the other evidence in the case. Look at all of it and render a verdict that speaks the truth. There is no mystery here, folks. It took a long time to get there, but it's not a mystery. There is only one verdict that speaks the truth in this case. There is only one verdict that will do justice for this beautiful young lady, and that is a verdict of guilty as charged. Please find him guilty. Thank you. She could have caused that damage from the passenger side. She could have caused that damage from the passenger side.